A High Court judge has found that there are serious issues with the way in which a local authority obtains a liability order for council tax. This has led many people to believe that liability orders don't exist, therefore they're not enforceable, therefore no tax is due on that property. Is any of this really true? That's what you'll find out in this video. But first of all, welcome back. If you're new to me, I'm Daniel Shen-Smith, a barrister of England and Wales, and I'd be really grateful if you hit that subscribe button so that more of my content will pop up on your feed, because many of you don't subscribe, and I'd be very grateful if you do. This particular case is the case of Leighton and Bristow and Suter, as I referenced in my previous video. And also, just as a heads up, this video is in part sponsored by emissions.co.uk, where you could be owed thousands of pounds for your vehicle, but more about that a little bit later. So let's get into this case. Now, I can't bring it up on screen for copyright reasons. I have sought permission to use this transcript of the judgment, but it's an unreported case, which means it's not in my standard law books or databases as I research. And instead, I only have a copy of a transcript which was sent to me, which I do not have permission to use. But I can talk to you about the points that were raised in this case, which are, to say the least, extremely serious. Now, the way in which a local authority obtains a liability order itself, as the judge noted, is problematic, to say the least. Because when somebody is overdue for their council tax, the council will go through various processes and ultimately obtain a liability order from the magistrate's court. These are one of the few things that remain the jurisdiction of the magistrate's court, which in itself, the judge noted, is problematic and ripe for reform. But the problem with it is this. When the local authority goes to the magistrate's court, they take along a list of alleged debtors and how much they are supposed to owe the council in council tax. Now, after hearing any representations made by the defendants or their representatives that do turn up, the magistrates then simply sign the list at the bottom, subject to any amendments, to confirm that liability orders have been made against each of those individuals. That answers the first question. But in this case, the judge found that on the balance of probabilities as to whether or not the magistrate's court made liability orders against the individuals named in that document on that court list, the contemporaneous documentation, the judge said, suggests that this was the case. When Mr. Leighton said that he had no recollection of such an order being made, the judge said he must have been mistaken, and the judge preferred the evidence set out in the documents, which confirmed that liability orders were made against each of those individuals. But it doesn't end there. The problems start really with the name. Whilst it is a liability order, it is an order of the court. But the judge noted that this is somewhat of a misnomer. In other words, the wrong sort of terminology to be used, because there is no physical order that we would anticipate from any other case. For example, when I go to court for any other claimant, if we win the case, we get a judgment. This is an order of the court for the defendant to pay a sum of money, or to do or not do a thing, if that were an injunction. Now, this would be a physical order sealed by the court, naming the parties, naming who was to pay what and within what time frame, and whether there were costs or interests involved. However, in the case of liability orders, the judge noted that there is no physical order. This makes the enforcement of such a thing extremely difficult, because what happened in this case essentially was that the local authority had instructed debt collectors simply with a list that was signed by one of its revenue management officers. But this wasn't good enough, according to this judgment. A simple signed list of individuals' names against whom liability orders had been made was not sufficient for the debt collector to then enter those individuals' premises and remove goods. But speaking of organisations that don't have their paperwork in order, many vehicle manufacturers are accused of manipulating the emissions readings on the vehicles that they've sold you. This is where my sponsor for this video comes in, which is emissions.co.uk. You see, if you've bought or owned a diesel vehicle from any one of these manufacturers between 2008 and 2018, you might have an eligible claim for something between 25 and 75% of the vehicle price, with over £100 million of compensation being paid out in the UK to date. The average claim is running into the thousands. What these manufacturers are accused of doing is installing software and hardware which will detect when the vehicle is in a test state and output a lower emissions than the vehicle would ordinarily do. If that were indeed found to be the case by a court, then the advertised emissions would be misleading. We call that a misrepresentation. If they did it deliberately and dishonestly, then it would be a fraudulent misrepresentation. You can enter your vehicle details at the link in the description below, emissions.co.uk, to see if you are eligible for a claim. And if you are, then the lawyers that will pick up the case will do so on a no-win, no-fee basis. But if you do win or they settle your claim, you could be owed thousands of pounds. So if you've owned one of those vehicles, you have nothing to lose by checking the eligibility of that vehicle at the link in the description below. And as always, I would never recommend something to you that I'm not doing myself. I am in this process myself of suing a manufacturer for one such vehicle. So check out that link, and now back to the video. So based on the judge's findings in this case, what is the ultimate outcome of this case? Well, ultimately, nothing really changes, because the ultimate finding is that liability orders are made by the magistrates against the list of names that come to court. However, any debt collectors that come to your address to remove goods under a liability order must be able to provide documentation to prove that such a liability order was made against you, meaning they must have all of the correct documentation. However, given that no physical order against any one individual is actually produced, not only is it not readily discernible, the judge said, as to who made that order in the first place, it is also extremely difficult for any alleged debtor that didn't attend court to challenge the order, to apply to set it aside, or even appeal it, as you would any ordinary judgment. However, what the judge also frequently said in this case is that he must remind himself that this was not a case against the local authority. It was only a case against the debt collection company and how they were enforcing the liability order and whether or not they had the documentation to prove that such an order existed. Now, if you happen to be on the unfortunate receiving end of a visit from one such debt collection company, if they do not have documentation to prove to your satisfaction that a liability order exists, you might indeed want to take formal legal advice on your specific circumstances as to whether or not that specific liability order actually exists. But ultimately, in this case, the judge found that on the balance of probabilities, the list of names that was signed by the magistrate means that the liability orders were in fact made. But the procedure with which these liability orders were made makes the enforcement process a lot more difficult. So I hope you found that interesting. Please do like the video and subscribe if you'd like to hear more about this. I hope I will get permission of the court at some point to use this transcript. But for now, hopefully my explanation has been enough. Please also don't forget to check out your eligibility for your vehicles with my sponsor in the link below. And as always, thank you for watching.